Students, this is part number 3 on foreign judgments. In first part, we have studied section number 13, in which it has been laid down that normally the foreign judgments are conclusive in India and will operate as res judicata within India, and it can be enforceable in India like a normal judgment. But if the case of the parties falls within any exception of section number 13, then it will not operate as res judicata in India, it will not be binding on the parties, and it cannot be enforceable by the Indian courts. In the previous lecture, I have already discussed clause number A and clause number B of section number 13. Now in this lecture, I am going to discuss with you clause number C and clause number D of section number 13. Now let us study clause number C. Clause number C says that the foreign judgment should be based on correct view of international law, or the foreign judgment should recognize the Indian law in those cases in which Indian law is applicable. But what will happen if the foreign judgment appears to be founded on an incorrect view of international law, or there is a refusal by the foreign court to recognize the Indian law in cases in which such Indian law is applicable? In that case, that foreign judgment shall not be conclusive in India. It will not operate as res judicata in India, and it will not be enforceable in India. Such a foreign judgment shall not be recognized in this country, and hence it is not conclusive of the matters adjudicated by the foreign judgment. But it is very important to note that the mistake must be apparent on the face of the proceedings. If the mistake is not apparent on the face of the proceedings, then that mistake shall not be regarded as material, and the foreign judgment shall be conclusive in India. Thus, in a suit which was instituted in England on the basis of a contract made in India, it is very important. It is a settled principle of law that law of that country will be applicable to the contract where the contract is executed. In this case, the contract was executed in India. The suit was filed in England. So in this case, the Court of England should recognize the Indian law of contract, that is Indian Contract Act 1872, and should decide the suit on the basis of the Indian Contract Act 1872. But if the English court erroneously applied English law instead of Indian Contract Act 1872, then the judgment of the foreign court will be covered by clause number C of section number 13, and it will not be enforceable in India. It is the general principle of private international law that the rights and liabilities of the parties to a contract is governed by the law of the country where the contract is made. For example, if the contract between two parties of different countries is made in India, then the contract will be governed by the provisions of Indian Contract Act 1872. This principle of law is known as lex loci contractus. That means law of that country will be applicable to the contract where the contract had been executed. Okay, this was something about clause number C. Now clause number D says that foreign judgment should not be opposed to the natural justice. Okay, if the foreign judgment opposes the basic principle of natural justice, then that foreign judgment shall not be binding on the parties and it cannot be enforceable in India. So what is written in the notes? The foreign judgment, to be conclusive, must not oppose the requirement of natural justice. What is the meaning of natural justice? The judge should not be biased. The judge must be impartial. Reasonable notice of hearing of the case must be given to the party. And reasonable opportunity of being heard should be given to the party. But if in any judicial proceedings, this principle of natural justice is not followed, then that judgment is null and void, that cannot be enforceable. That means that in the judicial process, it must comprise impartial persons and they should act fairly to both the parties to the case. It must give reasonable notice to the parties to the dispute and must give each party adequate opportunity of presenting their case. A judgment which is the result of bias or want of impartiality on the part of the judge, or a judgment which is given without notice of the suit to the defendant, or which is without affording a reasonable opportunity of representing his case, is opposed to the natural justice and will be regarded as nullity and cannot be enforceable in the Indian courts. However, it is very important to see that if a judgment was rendered by a foreign court after observance of the fundamental judicial procedure, I want to repeat, if the fundamental judicial procedure has been observed by the foreign court and due observance of the judicial process has been followed and thereafter a judgment is rendered, then that judgment is binding and conclusive, even though it might have proceeded on an erroneous view of evidence or law. It has been made clear by the Supreme Court of India in Y. Narasimha Rao versus Y. Venkata Lakshmi 1991, 3 Supreme Court cases 451. From all the discussion, it is clear that bias of the judge will bring the case within clause number D of section number 13 and will make the judgment as void, unenforceable. But it is very important to see that if the judge merely suggested, I repeat, if the judge merely suggested a compromise in the case or merely refused the request of adjournment of the case, then it cannot be inferred that the judge had any bias against any party to the case. Okay, it is also very important to see that if a judge decide a case and after the decision of the case he promoted in the appellate court then he cannot sit in appeal against his own judgment. If he sit in appeal against his own judgment, that will be opposed to the natural justice and it will not be binding. Proceedings of the court even cannot be said to be opposed to natural justice if defendant does not make proper use of the opportunity which was offered to him by the court. Okay, so this is something about clause number C and clause number D of section number 13. If you like my video, then kindly subscribe my channel, and if any one of you wants to get the hard copy of my notes, then they can take the printout from lawarticles2020.blogspot.com. Thank you very much.